Good evening and welcome to the second episode of Know Your Rights for Season 2. This is the show where you hear directly from lawyers who break down the law and explain the rights of citizens on common legal issues that confront Belizeans on a regular basis. Tonight, we will be discussing arbitration and mediation as alternatives to settling legal disputes. Joining us to shed light on this topic is attorney Liesje Barrow-Chung from the law firm of Barrow & Company. Good evening and welcome, Liesje.
Good evening. And
thanks for being here.
My pleasure.
I should probably say thanks for coming back.
Don't me.
You are the first attorney to have returned from your
pleasure.
Season 1.
My pleasure. My pleasure. It's always good to help.
And if anybody had missed your segment in Season 1, you spoke about encounters with law enforcement,
Yes.
police, and that was a very good segment. You got some very good feedback from that.
Thank you guys for the opportunity.
So you are here to discuss arbitration and mediation as alternatives. And I have to say that I do like this topic because I feel like as Belizeans we have this generic blanket thought that whenever we have a problem we have to go to court.
Yeah, it has been something ingrained in our society for a while, but for a long time our society had always had the predisposition that to settle anything you have to go to court.
Okay.
With ADR, Alternative Dispute Resolution, you have many other tools available to you in terms of settling. Mediation and arbitration are two of those more popular tools now.
Okay.
The mediation involves sitting with a neutral third party. So the two parties who have issues will sit with someone literally in the middle to try to help them to speak about their issues and see how best they can come to a middle ground.
Okay.
The arbitration is a little more formal in that you have either an arbitrator or an arbitral tribunal who act as judge or judges to determine the issues and to settle it. But it is more of a trial, informal trial, so to speak. It's not as formal as a trial.
So a little bit more than a mediation.
It is, yes.
So in terms of formality, you start with the mediation, which is casual, then you go up a level arbitration, and then you go up a level
and you go to litigation
with the courtroom setting, what we're most familiar with.
Which is more popular right now.
Okay.
But even the courts now, because of the development of our CPR, Civil Procedure Rules, they are now introducing mediation and arbitration as alternatives or other options available to us even at Supreme Court level.
Okay, so the question would be, what would constitute me going to mediation, arbitration versus litigation then?
For mediation, it can be a situation where parties can decide that, you know what, we can settle this.
Okay.
You're saying one thing, I'm saying another thing. We need somebody to help us to decide where we are and how best we can arrive at a solution.
Okay.
Arbitration tends to be more contractual in the sense that it is more in line with commercial issues. So if it is that there has been a breach of a contract, as one of the clauses in the contract, you would see that the alternative or the resolution to the dispute would be arbitration as opposed to litigation.
Okay.
So there has to be a contractual agreement where it relates to arbitration.
Yeah.
So if it is that there has been a breach or someone alleges a breach of the contract, you will check the dispute section in the clauses and it would say whether or not we're arbitrating or we're litigating.
Okay.
And that is how arbitration generally comes about.
Okay. And does it have to be voluntary on the part of the parties to enter into mediation? Because, for instance, let's say we have a dispute and we want to take it directly to litigation, which we're most familiar with. And perhaps a judge or somebody hears a dispute and say, you know what, I think we could have worked this out if we sit down in a room together and just have a mediator there and work it out. Does that ever happen? It
happens now, especially because, as I said, we have the CPR rules that have been amended to include mediation. So even when you start a claim, when we reach before the judge would look at it and say, but based on these pleadings, I believe you guys can work this out. So it is referred to as court-ordered mediation.
Okay.
So you don't really have a choice, but you have a choice.
Okay.
In those instances, when we do go to the court-ordered mediation, we are expected to go with the intent of trying to get the matter resolved.
Okay.
It doesn't always work. And in those instances where it doesn't work, we go back before the judge and we prepare for litigation. But there are those instances, more often than not now, where the judges are of the view that you just need to sit and talk.
Okay.
And in mediation, even though you've started the process through the court with an attorney, our role is not necessarily to command the proceedings.
Okay.
The attorney really and truly has a background position now. We're on the back burners now.
All right,
and it is really and truly the parties sitting and talking to each other with the mediator's assistance.
Okay. Really try to get them to discuss.
Right, to vocalize and say all the things that they would not normally be able to say in a formal setting.
And
So-
in terms of mediation, and I want to just dissect each one separately for a minute. In terms of mediation, we just spoke about discussing. So is it that the resolution, reaching there, it's different from when, for instance, a judge would give, this is the ruling?
Yes,
It's
yes,
different.
yes.
In what ways?
The difference is, as I said, you have a discussion with the parties. The mediator, the neutral third party, sits and he or she listens to what is being said and basically repeats so that you can hear it from someone else. Because sometimes we hear things differently when someone else says it.
Interesting. Yes.
So
yeah.
the perception is that with a buffer, someone who acts as a buffer, you can get more done. And it is not necessarily a situation where somebody projects upon you a decision. It is one that you both can come to. I think the best mediation results are those where neither of us are happy.
Oh.
So it means that you're not fully satisfied and I'm not fully satisfied, but it means that we were able to come to some middle ground.
Okay.
And we were able to walk away saying, all right, I'll live with that.
I could live with
Yeah,
it.
I could live with
Good
that.
compromise.
Right.
So this mediator is very important.
Oh, yes.
What qualifies for you to be a mediator?
To say that there's a specific qualification would not be true.
Okay.
Because you have different areas of disputes.
Yes.
So you may have land disputes, you may have something as simple as accounting, you have contract, you have engineering. I mean, it varies. So the parties can decide who they want to appoint as a mediator. So they may be more comfortable with an engineer when it comes to a contract dealing with construction than they would an attorney.
Yes, yes.
Because they don't think the attorney possesses the qualifications and the skills.
Yes, yes.
So it depends on what area you are in dispute over. You could choose the person best suited to you. And as again, both parties have an option.
Okay, in
Right?
picking the person.
Right. So
Yeah.
what we find is that a suggestion of 3 persons would probably go out.
Okay.
And of those 3 persons, you can both decide which of those 3 would be, to you, best suited to fulfill that position.
And in terms of the resolution now, mediation, as you said, it's different from litigation. When judge give the ruling, you have
That's
to
it.
follow.
Right.
Is it a similar case with the outcomes of mediation?
The mediation outcome, because it is something that both parties agreed to,
Yes.
it doesn't have to come in the form of a command or an order.
Okay.
So we can report to the court after in court ordered mediation. We can report to the court and say that yes, we were able to come up with a resolution, and this is what we have decided. And it can be the terms of an order, but it is more like a consent order, as opposed to someone descending upon us and saying that you need to do this, and the court hereby finds that. So it's not a finding by the court; it is an agreement between the parties.
Okay.
And it is reduced to writing and made into an order.
So you could never sure that the party want to live up to the resolution on their side or so after a mediation then?
More time than none you can be, but in the instances where they do not,
Yeah.
then you always have the option to go to litigation.
Take it the level
right,
further.
Right.
Yes. And the resolution, you said we try to meet this middle ground.
Yes.
So is negotiating a very big part
Oh,
in terms of the
yes.
parties
Oh, yes,
with
yes,
each other?
Yes, because as I said, we both want different things.
Yeah.
The question is how much you're willing to give and how much I'm willing to give.
Okay.
So there needs to be some negotiation, which is also another ADR tool.
Okay. On its own?
On its own,
Okay.
right.
Yes,
but
yes.
it is a part, and it can be a part of the mediation process, because you need to be able to give, and I need to be able to give too.
Yeah.
So it is necessary in that regard.
Okay, we just need to take a very short break.
No problem.
We'll be right back, and then we'll get into arbitration and have some more comparisons between the two alternative processes. So please stay, we'll be right back. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Liesje Barrow-Chung, and we are discussing arbitration and mediation as alternatives to settling legal disputes. So we started with mediation, which is the most casual of the two.
Right.
Yes, even more so casual than litigation. Can you give us some specific examples of cases that would go to mediation?
Easily. What you find, like for example, you have land disputes.
Okay.
I purchase a piece of property, but this property has squatters, for example, on the property. Need to help me get those people off. You're not giving me what I thought I was getting.
Okay.
So we come and we sit and we speak about the issue, whether or not I'm giving you back your money, or whether I'm trying to get the persons off, or whether it is that we're just going to subdivide that portion and leave the squatters there and I reimburse you. So that's one aspect where we can come together and we can try to find a resolution.
Yeah, make we figure things out.
Exactly.
Yeah.
Other issues involve simple things like family. So you have issues as to custody.
Yes, yes.
And it really and truly sometimes just requires persons just sitting and talking.
Yes, yes.
Because family, you know, is very emotional. And sometimes you need to get the emotions out, hear what is being said, and then we could get into the issue. So whether or not it is custody, maintenance, things of that sort.
Yeah.
You also have it in relation to administrations, like estates, where people die and they leave property. Someone is appointed as the administrator, but the beneficiaries are not getting their benefits. So we need to come again and sit and talk about this, Mr. Administrator or Miss Administrator, you're not doing what you're supposed to do. Can we please talk about this and see how best we can get this resolved? So those are just some of the instances where mediation would come into play.
And you have seen positive outcomes from mediation, taking them to mediation rather than higher levels.
Yes. One of the benefits of the ADR process on a whole is that it saves time, and by extension, it saves your client, in my instance, client, the costs, and I guess the whole process is shorter.
Okay.
So, I mean, if it is that we reach a point where we're settled, thing done, wrap up and go home. As opposed to having to go through the process of preparing for trial and getting witness and so many. So
then they change your date, then you have to go back.
Exactly. So it is shorter and it is less cost involved for the persons.
Let's now take it up a level, which we said is arbitration.
Yes.
So explain to us arbitration.
All right. Arbitration is essentially a trial, but it is more involved. The parties are more involved in that process. So for us to start arbitration, first of all, as I said before, we had to have agreed to it as the dispute resolution tool.
And you said this are usually in a
contract basis. Right. So having engaged that aspect of the contract, we are agreed that we're going to arbitration. The first step will be to appoint an arbitrator or a tribunal, which can normally consist of 3 people. Because what you do is to ascertain whether the arbitrator has any bias. Before you even get into what it concerns, the details of it, you would send an engagement letter to ask these preliminary questions to say, okay, Khadija has an issue, Liesje has an issue. Do you have any conflict? So that is very, very, very important in any arbitration process because you don't want the appearance of bias in anything that you do. So having selected this arbitrator, the parties with the arbitrator can decide the time, the procedure, location, things of that sort. So you are more involved. You will still need to give witnesses or witness statements or have a trial preparation, so to speak.
Okay.
So you will still give testimony, and you will still be required to do submissions.
Okay.
And
present your evidence.
exactly.
Just
Right.
like a trial.
Just like a trial,
Yeah.
except that you have more control.
Okay.
So, for example, in a court setting, sorry, you can't choose the judge.
No. Yeah. Yeah.
That's just the judge. You stick with that, and that's all you can do. In an arbitration setting, as I said before, because there are various areas that you can have issues over, you can choose the person who you think is best suited for that purpose. So, for example, a medical claim.
Yes.
There's a breach by some doctor or somebody in violation of the employment contract or whatever. They can decide to choose an arbitrator in the medical profession because they believe that that person is more familiar
capable of understanding
Same thing with, like I said before, the engineering.
Yes,
I mean, there are so many nuances to engineering that I can't even pretend to know.
Yeah.
But the parties, again, have an option to choose who they think is best suited and capable to do that. So you have a choice with the judge.
Yeah, take away or get.
Take away or get,
yeah.
right?
Deal
So,
with it.
exactly.
Yeah.
So it gives you a sense of comfort because you have confidence in who you've selected.
Okay.
And the selection, as I said before, is not done one-sided. Both parties, in this case, also have to choose. So it's more formal, but you have greater control and influence in it.
Okay. And what about the outcome? As we mentioned for mediation, the outcome is a resolution that both parties try to meet halfway and come to a compromise. But for arbitration, is it similar?
No, because in that situation, that's how it's most like a trial, because you have someone giving an arbitral award.
Okay.
So they're saying, this is what I believe is the resolution or the outcome of it. And with those types of decisions or awards, they can be either binding or non-binding.
Okay.
That's one of the things with arbitration.
Yes.
So the parties can agree that whatever the arbitrator decides, we will stick to it and it will be binding. So it is as good as any judgment.
I see. Yes.
In non-binding arbitration, the parties can decide, you know what? I don't agree with that. We're going to court.
Oh, okay.
So that is the difference.
Yes.
In those instances where we have agreed that it will be binding, and there has been, I guess, the person has not fulfilled their obligation or the aspect of the award, you do have the option to taking it to court for enforcement.
For enforcement.
Right.
Oh, okay.
Right.
Yes,
So
yes.
you have options available to you in that regard.
Yes. And you mentioned that how with the arbitration the parties have much more control. Let's go say, like your arbitrator, you begin this process. Is it possible to change your arbitrator?
If you're not happy,
Yes.
it depends on when you're not happy. You can't happy when the thing's done.
when you had it outcome.
Right. You can't not happy then. But if it is that during the process now, you're like, hold on, I need to get one good sense of this thing. It looked like it get kind of biased to me. You do have the option, especially where you are of the view that there has been misrepresentation, or you learn that through some association along the way, the arbitrator had some previous dealings with one of the parties. So you do have the option. You do have the option to change, even if it is in the middle of the things. But you have to, of course, put a case forward because it's not something that you want to do because you would have already wasted time, money, and effort. And one of the benefits of ADR is to save you time, save your money, and give you less effort.
Okay.
All right. So, but you do have the option.
Okay. We do have to take one more short break, and then we will be right back to continue our discussion on arbitration and mediation. Welcome back to Know Your Rights. I am Khadija Usher, and our guest tonight is attorney Liesje Barrow-Chung, and we are discussing arbitration and mediation as alternatives to settling legal disputes. So, we spoke on mediation, the most casual, spoke on arbitration, a little bit higher,
Yes.
and then we mentioned a little bit about litigation, which we're most familiar with and very serious, the court and so. But how do you determine when you have basically frustrated a level in terms of, for instance, you're in mediation, you go on and on and on, you're just not to get anywhere. Who determines that? The mediator?
That is where, right, that is where the mediator would come in.
Okay.
Because as I said, you have the neutral third party involved. And in addition to assisting the parties, the mediator would be the one to say, you know what, this isn't working out.
Okay.
The parties too can say that, you know, I'm not into this.
Yeah.
And they can all realize that it might be best for us to just go back to litigation.
We're just at that impasse
And it happens.
can't
It's
do it.
unfortunate, but it does happen. The thing with mediation is that you can't force people to mediate. So in family situations, example, you would want it to be mandatory, but you can't mandate mediation, so to speak. Yes,
Okay.
I can order you to go,
Yeah.
but I can't order you to be a part of it.
Okay.
So it is something that both parties, I think, for it to be beneficial, for both parties to want to be a part of.
Okay.
If you go and you're just not into it, you just don't even want to hear A from me,
Yes.
then we can't get into B to Z.
Yes.
So
So that means there are no specific types of cases or so that requires that you must go through mediation.
aside from, like I said, the CPR, the civil procedure rules, where we have court-ordered mediation and well, we're getting
Yeah.
into the arbitration aspect now. Aside from that being a mandatory attendance, there's no other situation where it's mandated and you are ordered to attend.
Okay.
And even when you are ordered by the court, it doesn't mean that it will resolve at that point. There are instances, as I said, where it has failed and you have to go back to the court for the court to make a determination.
Briefly, you mentioned earlier, and a couple of viewers might have caught it, that it would be good for more mediation to happen. And you mentioned a couple of reasons why, but I would just like for you to expand more on why it would be better for these alternative process, both mediation and arbitration, to occur.
My sincere belief is because it gives the parties a sense of involvement. When I'm preparing a case,
Yes.
I have control of that case. I get information, I get instructions from you.
Yeah.
As opposed to when we're involved in mediation and arbitration, where you're the one dictating what is being said, what you want to say, and how you want to say it. So, to me, one of the greatest benefits is the fact that you, the person involved directly in the dispute, have a control, more control over it.
Yeah.
You don't feel like somebody is telling you what to do. You understand? So,
Yes, yes.
and once it is that you're comfortable with that,
Okay.
it helps the process even more. Because you then have confidence in what you're doing, you then have belief in the process,
Yes.
and by extension, you want to be involved in the process. Whether it is that you want to get to the resolution or just get certain things ventilated,
Yes,
it
yes.
is an option for you.
Yeah.
So I think that's one of the major benefits of it.
The involvement.
The involvement.
And apart from the process, I had asked you earlier, and I meant to ask the question in that you're not really sure if the party will live up to his side or so, but you said more instances than others
yeah.
that they actually do.
Yes,
and
because like
that
I said,
involvement from the beginning.
Exactly,
you want to
because they
see.
don't feel like it was something imposed upon them. They had an option, they had a chance, and they were involved in it. Like I told you, mediation, when we go to mediation as attorneys, we dip on the back burner.
Okay.
So you guys sit and talk. If there's something that we want to clarify, we just say, excuse me, can we just make this point? And that's it. The parties are the ones who are talking to each other and trying to get all their issues ventilated so that they know what is involved. So at the end,
Yeah.
they know that they were the ones in charge.
Yeah.
And it makes you feel better about a process when you have more control about
Yeah.
over things.
The empowerment.
Yes, yes.
So do you need an attorney to go to mediation and arbitration?
You don't need an attorney for mediation because
Okay.
mediation doesn't always have to be because you've started a matter at court. You can
Okay.
have situations even at work
where there's an issue and HR say, you know what, let's get an independent third party to come in and help us resolve this matter.
Okay.
I mean, as simple as that. But it doesn't always have to be an attorney involved in that mediation process. Two people have problems in their house. You will call somebody else to come help. Mediation takes form in different ways. It doesn't have to be formal. It doesn't have to be structured. The arbitration process now, because that's contractually based, yeah, I would suggest that maybe you should get some help in preparing your witness statements and things of that sort.
Okay. And so I just want you to, I know this is hard, and all attorneys have problems with this last question when they come on the show.
Let me hear it.
In that I want you to really give the points you want to emphasize to the viewers on mediation, arbitration, the points you really want to emphasize and leave with them right now.
I would like them to understand that it is something that is available. You don't have to be limited, and you don't have to feel as if you need to have money to do things. There are alternatives, and I would love for our society to become more aware and take full advantage of these alternatives available to them. It's cost efficient, it saves time, and you are more involved in the process. It is not something that is limited to only court matters. In your everyday dealings, it can be a part of your own resolutions within your home or outside. So it is good. It is good.
Okay.
So.
I think that Judge Judy get way into this whole court thing.
I don't know who, but
TV time and everything.
But it is alternative dispute resolution on a whole is something that is I would promote.
Okay.
Because it helps. It really does help.
Yeah.
So.
Yeah. Well, thank you, Liesje,
My pleasure.
for joining us. And unfortunately, we have come to the end of our show for tonight. Thank you again for joining us and providing important information on tonight's topic. Next week, we will be joined by attorney Darrell Bradley, who will address some of our constitutional rights. Tonight's episode of Know Your Rights repeats at 1 p.m. on Sunday on Channel 7, and it will also be available for your viewing on Facebook and YouTube. Thank you for watching, and good night.